All right, today we're going to talk about a really powerful tool in the legal world, one that a lot of people just don't fully get: civil mediation. Think of it as a way to solve disputes that puts the power right back where it belongs, in your hands and far, far away from a stuffy courtroom.
So, are you facing a civil lawsuit? Maybe it's a contract issue, a problem with your neighbor over a property line, something at work. Whatever it is, it can feel like you're just staring down this long, dark tunnel. It's incredibly stressful, and it's so easy to think that a huge court battle is your only way out. But what if it isn't?
And that's the thing about a traditional lawsuit, isn't it? It really does feel like a labyrinth. It's this whole process that's just known for being super expensive, taking forever, and everything plays out in the public record for anyone to see.
I mean, we're talking about court cases that can drag on for months, sometimes even years. And all along the way, you're racking up massive legal bills for court fees, expert witnesses, you name it. Plus, every single thing that's said or filed, it becomes public information. This is the exact set of problems that mediation was designed to fix.
So let's talk about that different path. Let's really get into what civil mediation is and how it gives you a structured but still really flexible way to settle a dispute.
At its very core, mediation is basically a private, guided conversation. You've got this neutral professional, the mediator, whose job isn't to pick a winner or make a decision. Nope. Their only job is to help both sides talk, negotiate, and hopefully find a solution that everybody can actually live with.
I just love this simple way of putting it. It really cuts through all that complicated legal speak, right? It's not a fight, it's a conversation with a referee, a facilitator. The mediator is just there to make sure the discussion stays on track and actually moves toward a solution.
Now this is where it gets really important, because people mix this up all the time. Mediation is not arbitration. The huge difference is control. In mediation, you and the other person control the final outcome. In arbitration, someone else, the arbitrator, acts like a private judge and forces a decision on you. With mediation, you're never ever forced to agree to something you don't want.
And that brings us to the 3 huge benefits of mediation. Let's break down exactly why this path can be such a game changer. It really all boils down to saving your resources, keeping your privacy, and staying in the driver's seat.
So, the first major benefit? Speed. It's a big one. While a court case can literally eat up years of your life, a mediation is very often wrapped up in a single, focused day. Just think about that for a second. You could have a resolution and be moving on with your life in a few hours, not a few years.
So to quickly sum it up, you're saving a ton of time and money by sidestepping a long court battle. Everything you talk about is confidential, which means your business stays your business, not public record. And maybe most important of all, you get the flexibility and control to craft a unique solution, something a judge could never order, like a special payment plan or other creative terms.
Okay, so maybe you're thinking, this sounds pretty good, but what does it actually look like? What happens on the day? Let's pull back the curtain and walk through the whole process, so it feels less like some legal mystery and more like a clear, manageable plan.
First off, who's in the room? It's actually pretty simple. You've got the disputants, that's you and the other party. You have the neutral mediator, who's just there to guide everything, and you'll have your lawyer right there with you, giving you advice and looking out for your best interests the whole time.
The day itself usually follows these 4 steps. After the mediator lays out the ground rules, the real work starts in what are called private caucuses. This is where you and your lawyer meet alone with the mediator, usually in separate rooms from the other party. The mediator then basically shuttles back and forth, carrying offers and counteroffers, talking through the case's strengths and weaknesses, and helping everyone get closer to a deal. If you get there, the final step is writing it all down in a formal agreement.
And that leads us to the final and most crucial question. After all that work, after you've finally reached a solution, does it actually stick? What kind of legal power does this agreement really have?
And the answer is a big, resounding yes. While the process itself is non-binding, meaning you can get up and leave anytime you want, the second you and the other side sign that settlement agreement, it becomes a legally enforceable contract. A court will absolutely enforce its terms, just like any other contract you'd sign.
So it really all comes down to this, doesn't it? When you're facing a complicated, expensive, and very public lawsuit, it's worth asking yourself, could a private, structured, and empowering conversation be the real key to finding your resolution and finally moving on?